and gentlemen, I appreciate you sticking around for our last forum of the evening. This will be the forum for the two candidates for the open seat on the Superior Court right here next door. It used to be in this courthouse where you're sitting many years ago, but that seat is being vacated upon the retirement of Judge Jackson Harris, who I'm sure many of you may know or know of. And he has announced that he is retiring, so both of these gentlemen have qualified to run for that seat. Again, the Superior Court would be the court of general jurisdiction, and that would hear a whole range of civil and criminal cases at the trial level. The last group were the judges that would grade their work, sometimes unfairly and sometimes fairly. And these folks are doing the hard work of seeing folks like you, maybe not you, but people every day in their courtrooms. So without further ado, one thing I wanted to get out of the way is a very important housekeeping matter. Is none of my questions have been prepared by my spouse, and if you were to win, you cannot hold against her any harsh questions. I don't intend to ask any, but we need agreement. She's not going to hold against her. She had nothing to do with it. My wife has to appear before she wins this race. So anyway, I'm going to start with opening statements, and wow, a B and a C. The last guy was focused on being on the alphabet was unfavorable to one of them, but you both are near the front, but you're just a little bit ahead, so I'm going to give an opening statement. I've got a plan, by the way, of fixing that. You have to just scramble the names every time you go in the electronic ballot, and then it would be fair.
Then I will change my name to Tony
Aaron.
Triple A. Yes. All right. Well, welcome everybody, and I thank you all for having me here. Can y'all hear me back in the back?
Yes, sir.
All right. And I don't think I've ever been accused of being too quiet, or soft-spoken, but just a little bit about myself to you all who's not familiar with me. I'm Tony Baker. I'm 51 years old. I'm married to Tiffany Baker. She's sitting right up front here, beautiful lady. And my mean daughter Annabelle is here with her. My son Tate, he's 20, Annabelle's 18. She's going to be taking off to Georgia in the fall. I came here via Saigon, Vietnam in 1975. And I was adopted by my late father, Elliot Baker, and my mother, Jeannie Baker. And when I came here, this community was very welcoming and open. And I came here in 75, got put in the 3rd grade, learned to speak English, lost French and Vietnamese, and I still can't speak English well, but I try my best. Margaret and all my teachers taught me, and I graduated from Cherokee High School, went off to the University of Georgia, graduated from there in 1989, went off to Mercer Law School in 1992, and excuse me, I've got a little sore throat, so if I take a pause, but it's not because of anything, but I need water. Graduated in 1992 and came back from Mercer to practice law here in Canton. I was a trial lawyer for 15 years. I practiced with my father. He was county attorney, and then he got out of that and he tried a lot of cases. He had a wide range of practice. And so what I did, I think 9 months into my practice, I had a jury trial. I tried cases. I was a trial lawyer, and I practiced law for 15 years, and I tried thousands of cases. And I've had probably 30 or more jury trials under my belt, criminal and civil. And I've done domestic work, juvenile work, had a wide range of things. And in 2007, I got appointed to the juvenile court bench when Judge McElroy was appointed to be Superior Court judge. And I'm going on my 3rd term. I was appointed twice, and this is my 3rd term. I'll finish it up in December. And since I've been juvenile court judge, people seem to think that juvenile court is just kiddie court and that you don't have, it's not serious. But it is serious because a lot of people don't understand that in juvenile court, you hear terminations of criminal rights. You hear cases about kids who are in defense care because parents have issues and they can't care for them. We also hear some serious delinquency cases. So it's a serious court, and again, I've tried a lot of cases, thousands of cases in juvenile court, and then for the last 11 years, I also sit by designation as a Superior Court judge, and in the last 11 years, I've heard numerous cases, thousands of cases. I hear family violence cases, criminal cases, a lot of domestic cases, and they go to trial and they're lengthy. I also hear paternity cases. You name it, I've heard it. And if these Superior Court judges didn't have faith in me, they would not have said, Tony, you sit as a Superior Court judge and help us out because we need your help. I literally, looking back at my calendar from last year, I took count. I sat in Superior Court last year for 2017. I sat for 59 days. And on average, there's some people out here who know, who've been in front of me, on average, my calendar is about 10 pages, 10 cases long. That's average. So if there are 10 cases, and I've sat for 59 days, you're talking about 500, 600 cases I've heard a year as a Superior Court judge. So extrapolate that over an 11-year period, that's several thousand cases. So I've got the judicial experience, first and foremost. I've got the trial experience, first as a trial lawyer, and then as a judge. I've got the community involvement. I'm involved in my community. I've always been involved in my community. My father always told me, and I've tried to follow this now, give back, because then you've gotten so much from your community. And I have. Those of you who have interacted with me know, if you need me to do something, I'll do it. Many times a year, I will go and talk to kids who are in programs such as Teach One to Lead One, it's a character building program. I'll talk to them. I will also go talk to kids who have graduated from programs such as Strengthening Families. I go talk to church groups. I go to schools. I tell them whatever they want to know about the juvenile court system, and I tell them like it is. I'm not going to sugarcoat it. And that's my philosophy as a judge, too. If you elect me to your Superior Court bench, I'll be honest with you. But I'll be fair with you. And anybody that's been in front of me, lawyers know, and litigants know. I am efficient, I am timely, and I get things done. I know that everybody's time is important to them because I was a practicing lawyer. So when court starts at 9, I usually come home about 9:05 because I get the lawyers in, because there's nothing more distracting than getting in there and lawyers coming in. But I get on the bench, lawyers will tell you, I say to them, get your stuff ready. I know you have to be in another courtroom. I'll get you out of there. I will do the same as your Superior Court judge, and you will get the same treatment from me as you would everybody else. You can expect me to be fair. I ask you for both of them. Thank you.
Thank you, Judge Baker. And Mr. Chambers, will you give your opening?
Yes, sir. Thank you very much. First of all, I'd like to thank Ms. Baker, Ms. Wallace, and the Cherokee Republican women for giving us this opportunity. And also for all of you for attending. It's getting late, and I know it's a burden for you to do that. My name is Benson Chambers. I'm 60 years old. I'm a lifelong resident of Cherokee County. I've been practicing law for 35 years in private practice in Cherokee County and in just about every other county in northern metro Atlanta. I have also served for the last 18 years as the solicitor for the City of Canton Municipal Court. I've had a very diverse range of legal practice. I grew up in a time when you could just about set every lawyer in this whole county right here around this table. And we at that time took anything in that came through the door. That's what you were told to do and taught to do. My exposure ranges from personal injury to medical malpractice, products liability. I've even had a little breast implant exposure as well. A lot of contracts, a lot of business. I represented Cherokee County for 4 years. I've also represented and done work for the City of Canton, the City of Holly Springs, the City of Ball Ground, the City of Woodstock as well as a number of authorities, including the school system, the Water Authority, and also Canton Development Authority, excuse me. So I've had a lot of exposure to the law. I think I can apply that law to the judgeship. If any of you, and I can ask this question, if any of you have ever served on jury duty, you find out that you do a lot of waiting. Right now in Cherokee County for 2018, your judicial system is costing you $15 million in budgeted tax revenue. One of the reasons, and I've seen this not just in Cherokee County, we've had pretty good judges in Cherokee County, but in all the other counties as well. One of the reasons is court's never on time. It's always starting late. I've waited as long as an hour and 45 minutes for a judge to show up to start court. Everybody's still sitting there. When that happens, court goes on to 8 and 8:30. I promise you this, we'll start court on time every time. Or there'll be somebody else there to start court on time every time. When you have jury duty and on that first day and you're sitting downstairs and nothing's happening, and you never get called upstairs, we'll find some way to fix that. I think I know one. We'll move those pleas that you're waiting on to a different time. One of the things that I recently learned about is something called Veterans Court. There are some other specialized courts, DUI court, drug court, and I've done some looking into this, and I think it's something certainly appropriate that we should do, and it's something that I hope to do. My father's 85 years old. He's sitting right back there. He was in the 82nd Airborne during Korea, and he has taken the opportunity to have his medical treatment done with the VA hospital. This court system would take veterans, first-time offenders, put them into rehabilitation, redevelopment, connect them with VA opportunities that they deserve, and that's something I think, even if I'm not elected, we need to do. Mr. Baker and I have been friends for a very long time. Yes, I knew him when he didn't speak English.
You probably wish I still don't.
But I was quite surprised when it came out Southern. That was the big surprise.
Margaret Klein was my teacher at Patrick Canoni. What do you expect?
But we do have some other things in common. I practice law with his dad too, so.
Well, I appreciate that. I don't want to cut you off.
No, you're fine.
Good. Well, that was actually a good segue to my next question, because this is still somewhat of a small town. It's certainly a small legal community, and I know that you guys have known each other for a long time, but you're running a contested race, and the people have to know. And I'm going to start with you.
Okay.
What makes you the more qualified candidate? What specifically distinguishes you from Judge Baker in serving on the Superior Court?
Well, it's pretty easy to say that I've got 10 more years of experience. And that experience has actually been out on the street. It's been with real people. It's been with real businesses, people that had problems that needed to be solved. I've got a case right now, the Court of Appeals judges, I'd like to have an opportunity to speak more to them. I've got one in front of the Court of Appeals right now that involves a family, a young family that's had an insurance company that's covered their house for over 17 years. Their house burned down. The insurance company said, no, we canceled your policy. Right now, I'm winning that case. I won it on the local level. But it took a year. It took a year to get a decision from the judge before we could ever move forward. It's pending in the Court of Appeals, and hopefully we'll win again, because that family needs some relief. They've been for over 2 years living with family, and we're going to find that relief for them. Secondly, like I said, my exposure has been not just in one court. It's been in multiple courts, federal court, different county courts, and every court's a little bit different. Every judge runs their cases a little bit different. I want to bring to this court judicial economy that is moving these cases forward, making sure, we talk about heavy caseloads. Court of Appeals talks about heavy caseloads, but I've never seen anybody do anything about it. There's no reason in this world we can't move those cases forward, get those cases started, get court started on time, and we'll be able to make a difference.
Same question for you, Judge Becker. How do you distinguish yourself? What sets you apart from Judge Chambers?
I've been a lawyer for 26 years. Like I said in my opening, for 15 years I was a trial lawyer. I tried cases. I'm familiar with rules of evidence, how to try a case. I went from the trial courts as a lawyer to the trial courts as a judge. I spent 26 years in the courtroom. I sit as a Superior Court judge. In addition to hearing over 1,000 cases, averaging about 500, 600 a year, I also hear about 800 cases in juvenile court. And like I said, I am efficient, I am timely, and I get lawyers who live this out of there. One thing everyone looks for when you go do anything is experience. Between Benson and I've got the judicial experience. 11 years going on 12. I've got the judicial demeanor. I've got the judicial rulings. I've got the trial experience. I've got the community involvement. What else can you ask for? I just want to extend my time from juvenile court, filling in part-time as a Superior Court judge now, and make it a full-time job. Why not? I've got the resume for it. I know the people just like Mr. Chambers knows the people. I'm getting out there and beating the bushes. I want this job, and it's an extension of my career. Nothing that I planned for, but this is what the Lord has planned me to do. I'm going to follow that. And I didn't do this lightly. I prayed about it, and I'm following it, and I'm going to run, and I want to be the next Superior Court judge because of my experience and my involvement and my time in this community. Thank you.
You mentioned courts starting on time. Specifically beyond the judge starting court on time, what are the other things that can be done to make cases move along?
Attorneys tend to be procrastinators. And one of the things that I certainly know is when the judge looks at you and says, you're starting Monday morning at 9 o'clock, then you need to be getting ready. Too many times we've had jury trials when all the cases fall apart. There needs to be some way to back that up and tell them, you have your case settled or your client's going to be guilty on Friday before trial starts, or we're going to start Monday. The next thing has got to be time management within the office. So many cases get heard by a judge and then their actual decisions are made outside your presence. They're made in written decisions. And quite frankly, they take too long. This one I was telling you about that just went up, it was over a year. And then the judge wound up signing off on the very order that I prepared. And you've got to be on a Friday afternoon. You've got to be in the office working.
Same question to you. Are there certain measures that can be taken if I guess the first question is, do you believe that currently, as a general matter, Superior Court cases don't move quickly enough? And if you do believe that, is there anything that you believe can be done to make them move more quickly?
Well, let me explain a little bit to those who aren't familiar. Jury trials, yes, jurors wait. And I remember this as a lawyer and as a judge when I filled in. Clients, I'm not guilty. I'm going to trial. We're going to go to trial. Right now, we're going to do it. Judge, wait, that's ready. Monday morning comes, you call your client, the jury's downstairs. You ready to try your case? Can you hold off a minute? I think I want to change my plea. It happens all the time. And you know what? That's part of the system. Jurors, when they come and it's time for the rubber to meet the road, a lot of defendants will plead out. And a lot of times we do say, when I say we, I'm talking about Superior Court, I fill in, but Superior Court sets counters down for pleas. Where you've got a lawyer you've hired. This lawyer can't just be here. He has to be in Cobb County, he has to be in Bartow or Pickens, and the priority of cases take precedence. The older cases criminally take precedence over civil cases. So that lawyer has to report to the other courtrooms, and they have to be there or the judge gets on to them. So it's not an inefficient process. It's a process that has happened through the years because lawyers have to prioritize their time, and they have to come to court when called. And believe it or not, the jury system, it works wonderfully because when those jurors show up, 9 out of 10 times those defendants say, we want to plead. And then that's why you have Mondays where there's a lot of pleas, and I filled in and held the pleas because the calendar just falls apart. But you know what? If you can get rid of 15 cases through pleas versus one jury trial for the whole week, by all means, do pleas. You clear up your calendar, and that is what you look at. You look at the efficiency of the number of cases you dispose of. And part of the discomfort is that jurors do have to wait. But a lot of times I know judges will say, take a long lunch, come back, we'll deal with it on Tuesday.
Are cases set for trial before the jurors are called in as far as the ordering of the cases? Is there a calendar call that occurs before the...
You know Shannon told you.
She didn't tell me.
All right, the way it works, you ask me first?
Yes.
The way it works is you do a calendar call for a civil or criminal case, and you go through. And the older cases, the cases that take precedence are jail cases or demand cases. Demand cases are cases where lawyers have filed a speedy trial demand and you have to try it within 2 terms of court. So those jail cases and demand cases take precedence. Then the cases that are the oldest follow in line. So let's say you have a 20-page calendar and you've got 100 cases on there. They call calendar, the lawyers say, I'm not ready, subject to negotiations. All right, not ready, we need discovery. Not a problem. So they go through the whole calendar. Then the state says, all right, judge, we'd like to try this and this and this. So the judge will get together with all the lawyers at the end of the calendar call and say, all right, first, all the jail cases and the demand cases go. Then the next 3 pages of cases that have announced ready show up on Monday, May the 1st. We're going to try it. So those 5 pages show up along with the jail demand cases, and then when they get to court, that's when you start seeing the wheels of justice grind. It may be slow, but it's fine and it works. I promise you it works. And then when it falls apart, there are no more pleas, there's still a case. Try your case. Pick the jury. Bring the jurors up and you start striking the jury. And that's how it works. You do calendarize and you prioritize.
So specifically with respect to how they call in cases for trial, how they bring in jurors, is there anything they can do differently? I understand that you won't be the chief judge of elect, and neither one of them will, but is there anything that can be done differently that will avoid jurors coming and having nothing to try and things like that?
Yeah, I think there's a lot of things. I understand that, some of them, I've seen this, I've been there, real life, real world. Some of these pleas take 40 minutes. 45 minutes. There's no reason they can't be shortened down, you know, so that they can get in a lot more in the same space. But why not on Monday morning when you show up and suddenly you've got all these criminal cases and decide to plea, move those pleas till later in the day, or move those pleas to Monday or Thursday when the trials that are ready to go are already heard. We wind up with basically 3 days of jury trials in a week, sometimes more, but mostly, basically, 3 in a week.
I have a question from an audience member regarding the perceived increase in the number of pro se cases. Maybe on the criminal side, but I'm not exactly sure. I'm reading into the question. Is that a real thing? And if it is that a problem? And if it is, how do we solve it?
You want me to go?
My question, or?
I actually am trying to alternate so each of you have time to think about your answer, so I'm not unfairly making one person on the spot every time.
That's fine.
So you go, then you can ask the same
Sure.
question.
It is a real thing, and what he's saying about pro se is someone representing themselves.
Sorry. Some of these terms.
Someone being their own lawyer. And I have that situation in a case that's just concluded, where a person who was really wrong in what she believed. She was a real estate agent. She was suing my client, a property owner, because my client hired somebody else. So she was suing my client for breach of contract that never existed. She had somebody helping her that knew a little bit about the law, that knew a little bit about the procedure, and knew how to quote a statute, but they were just totally wrong. That case went on for over 1.5 years. Every time there was a ruling from the judge, she filed an appeal with the judge to reconsider. When we finally got the cases dismissed, there were actually 2 defendants. I had one of them. When they got the cases dismissed on summary judgment motion, she filed an appeal to the Court of Appeals. We had to respond in answer to these cases in every situation, or otherwise my client, who was totally innocent of anything, had no idea that she had never made an agreement with this particular agent that cost her thousands and thousands and thousands of dollars. It would have been grateful, maybe helpful. Maybe at some point, the judge couldn't do it, but maybe at some point, if we had somebody that could go to these people that are pro se and say, here's the situation, we may want to consider something alternatively so that we don't waste the dollar amounts that are required from people to defend themselves.
Same question.
Well, let me say something. When you represent yourself and you're pro se in civil court, you have no right to a court-appointed lawyer. So a pro se person in a civil case, if I were to sue, somebody out there for a car wreck or something, or they were to sue me, they have an absolute right to use the court system as it is, and there's not a problem with that. It drags it out because they don't know what they do, but they are subject to the same rules of evidence and procedures as lawyers are. Now, when it comes to criminal defendants, when it's a serious case, we have indigent defense over here. And what happens is, as judge, we screen them at arraignment, and we'll say, have you talked to indigent defense about getting a court-appointed lawyer? Do you qualify for one? If they say no, I'm going to represent myself, when it comes time, I put it on the record, I ask them your name, education level, can you read and write? I go through certain rights to make sure that what they're doing is freely and voluntarily done, and that they know exactly what they're doing. Then I also tell them, if you want, go to indigent defense, fill out an application, they will appoint you an attorney. Because a person trying to handle a criminal case by themselves makes the worst mistake. And I seldom allow anybody in criminal court to do a case representing themselves. Now, if it's a traffic ticket, that's different. But if you're talking about a felony, more than likely they're going to get a lawyer to help them. Or if they see that they're in trouble, they will all of a sudden come up with the money and hire a lawyer. And then once that comes in, then you get discovery and you get the process ready. But what Mr. Chambers is talking about is a civil case. And a person has an absolute right to file a suit civilly, and you go for it. That's some of the pitfalls that I have to deal with when I sit in juvenile court and in superior court. We have pro se litigants. We just have to take our time, walk them through it, and work it out.
Thanks, Judge Baker. And now I'm going to start with you. And these questions are kind of being thought of as I hear what you're saying and what you're wanting to talk about and the kind of points that you're making. So I want to follow back up on court moving as quickly as it should. My question for you is, when you're sitting on the Superior Court bench, are lawyers showing up on time? And I practice in federal court. I don't practice in state court much, and I'm rarely on time for anything. I was here tonight on time, but I'm never in my career have been late for court in federal court because I'm scared of what a federal judge would do. I know of lawyers who don't go to federal court because they're afraid of what federal judges will do to them. Is that same fear in when it comes to Superior Court? And if it's not, why is it any different? Why do lawyers get to show up late and get nothing more than perhaps a little bit of a slap on the wrist? And if that's not happening, tell me that that's not happening.
Overall, it's not happening. The problem is a lot of times you get on the bench and you call the calendar, because when I get on the bench in juvenile court and Superior Court, I go through the calendar. I get an announcement of what's going on. So, you know, I'll say, John Doe, attorney is Jane Doe. Where is she? Well, she called office this morning, she got a sick son. Okay. Or, you know, John Doe has to be in Bartow County first. Where's the conflict there? Here's the conflict there, Judge. You have to work through it. But overall, because this is still a small, close-knit community, if you're going to be somewhere else and you can't be in the courtroom and you've got priority cases that are older, and all of a sudden, let's say Judge Harris says, I want you here today for a plea. All you got to do is call, hey, Judge Baker, I'm going to be down in 2C, I'm going to take a plea, I'll be up as soon as I can. Y'all all have seen that. We try to be collegial and work with each other. There are instances where lawyers don't show up, but at the same time, you've got to be understanding. You can't expect them all to be in your courtroom at one time, because that's kind of selfishness, unrealistic. Because as judge, everybody wants their case to be heard right away. But you can't hear their case right away. If their case was filed in 2018, and I've got one that's pending in from 2015. So they can say to the judge, well, he didn't hear my case. We have to prioritize also. So it's a give and take, but overall, no problem.
Okay. Same question to you. The lawyers get away with too much in state court.
I don't have any conflict with what Tony has said, because I'm practicing law. I'm practicing law right now, and I know how hard it is to make it to every court that I'm supposed to be in on any particular court day. I certainly agree. I've seen unfortunately, too many judges go on the bench and forget about practicing law. Forget that you've got people in your office waiting on you. Forget that you've got phone calls to make. But when you have to be in court, and I am always on time, I make sure that I'm on time. Somewhat like Tony said, I'm afraid of what's going to happen to me or to my case. But I also understand that because I have to be in a different courtroom, as long as I let somebody know that they can let the judge know I'm in a different courtroom, that's fine. You know, we have to accommodate those kind of things, and I will do so.
Okay.
I'll stay human.
Understood. So I'm going to go back to you with the next question, and I'm reading an audience question. It's an appropriate, helpful question. So I'm just going to read it as written. Do you support the continued expansion of accountability courts? If so, why? If not, why not? And I'll ask you, in answering that question, for those in the room that are not familiar with the accountability courts, provide some explanation as to what those are.
Speaking to the mic, please.
Okay, I'm going to start that question over. This is an audience question. Do you support the continued expansion of accountability courts? If so, why? If not, why not? And again, what I mentioned is some folks in here may not be familiar with what those are. So would you just explain briefly before you give your answer what the accountability courts are?
And I presume you're referring to DUI court, drug court, and those.
The ones we currently have in the Superior Court, which I believe are the drug court, DUI court, and you have
Parental accountability court.
Parental account, I don't know what that is, but parental accountability court. It's a good thing, sounds like it.
I do support those because
Oh, we have a mental health court.
Mental health court,
Yeah,
too.
How about a veterans court? Do we have a veterans court?
It's starting.
All right.
There's only one veterans court currently in Georgia based on what I've seen, and I would certainly like I said before, try to get that done.
I'm going to ask Judge Holmeyer to clarify all the courts, all the accountability courts in Superior Court. Can you
In
clarify?
Superior Court, there is Veterans Court, which is run by Judge Morris, and he does misdemeanors and felonies. Judge McMahon runs the felony drug court. Judge Cannon runs the parent accountability court, which is for people who had difficulty paying for child support. Judge Wood runs the mental health court that handles both misdemeanors and felonies. And we also have accountability courts in
apply at the Superior Court level? Could the Superior Court cases be referred to all those courts?
Veterans Court, Judge Morris runs both felonies and misdemeanors, so when he handles a felony case, he's sitting in special designation as Superior Court Judge. Judge Wood, who's the probate court, handles felonies and misdemeanors, so yes, felonies go through mental health court. Actually, the correct name is Treatment Accountability Court. And Judge McLean runs the felony drug court, which obviously goes for felonies as well.
Okay, so all those felony cases can be referred to the accountability courts for disposition if someone, if I guess the prosecutor agrees in some instances. I don't know all the details, but essentially this is a modern way to handle criminal cases for those people that need help. And so it's a way to divert, I guess, from the traditional crime and punishment model for certain individuals that are believed to qualify for those different kinds of courts. So my question is, do you support the continued expansion of accountability courts? I guess you could just generally give your impression of how they're working. If so, why? If not, why not?
I do support them, and in Kent Municipal Court, we sometimes send DUI cases that need to be sent to DUI court for basically follow-up, also for treatment, and also for the opportunity to rid themselves, of an alcohol problem. I have a client who currently is in DUI court, and I've represented her in her case. And she is doing quite well, very well. You would be surprised. She is the wife of a dentist. And you wouldn't expect that necessarily, but she had a problem. And her problem exhibited itself at 1 o'clock in the morning on I-575 when a state patrolman pulled up beside her and she was doing 40 miles an hour at 1 o'clock in the morning, not real sure where she was going. She is now into her second year of DUI court, and it's been a good thing for her. And as far as I can tell, even personally, she hasn't had any wine in this case. Hasn't had any since she started the court. So yeah,
Same question, your view on accountability courts, is it working, should they be expanded? And when I say working, I'm talking about here in Cherokee County.
They are working, and we're also looking at hopefully getting family treatment court. Let me tie that in by saying that drug court has graduated 64 people over a 5-year period, and the latest data I got was that of those that have graduated, there's like a 33% recidivism rate, which is lower than national average. Also, the national average is 47% graduation, and we're graduating at 50%. Now, what you got to remember is drug court is tough. It's 18 months, and a lot of people drop out, but the ones that don't drop out and complete, then you're having 20 to 33% recidivism rate. So what you got to think about is the governor has said criminal justice reform is going to happen. We need accountability courts because our jails are filling up with low-level offenders. And so we're on board. We need to be proactive instead of reactive. And our courts are doing that. Not only mental health court, because I know Judge Wood and I talked, and they're doing well. But again, you can't save all of them because not everybody wants to succeed. But the ones that do make it, you don't see that. And the way I look at it, if we've got a 67% success rate from drug court, that's 67% of people that you didn't have to lock up in jails. Because in the past, you mess up, you got a 2 or 3 year prison sentence. But now, yes, you mess up, there are consequences, but you still need to stay in court. I would much rather get somebody in the drug program, let them pay for it, let them learn, break their habits. It's an ongoing process. It takes a long time. We can do it. We've been doing it. And, we got to because the opioid epidemic is so bad now. I mean, we jumped from 10 to 54 ODs from 2000 to 2015. That's a 540% increase. So if we don't have accountability courts and we don't expand it, we're just going to be going against the tide. And so we've got to get on board and help.
Thank you, Judge Baker. Next question is, can you identify just one of the judges that you know or a famous judge that you admire and tell us why?
Okay, I'll tell you one. I guess it's my turn to go first, right?
It is.
Yeah.
Your turn.
Judge Mills, he's a senior judge now, and I admire him. I admire Judge Dover too, Judge Harris, but Judge Mills, I say him because he went on the bench as a DA at 32 or 33, and he was Superior Court judge for 30-something years. And Judge Mills was tough. He was tough on you as a lawyer. He expected a lot out of you, but he was also fair. And the thing about Judge Mills, this is what I can say with certainty. He's a big old teddy bear, but he knows his stuff, and he expects the best out of you. I don't believe in the history of this county that a guilty plea has ever been reversed when Judge Mills or any other judge has taken the plea. Because a lot of times you get reversals because you didn't do the Boykin rights. Boykin rights are rights that you have to read the defendants and you have to be thorough. There has to be a factual basis for a plea. I promise you, if you're in front of Frank Mills, and these lawyers know, sometimes pleas do take an hour, but I promise you one thing. If they're guilty, it's going to come out. If they're not guilty, he's not going to accept it. I learned from Judge Mills early on, the best way to do something is just to jump in with both feet, and you will learn. He says, he told me when I had my first murder case, he's like, I said, Judge, am I ready? He goes, you're ready as you'll ever be. I'd been out of law school a year. And I just looked at Linda Haynes, Lady Linda Haynes, and I said, what just happened? She says, congratulations, you just got Judge Mills to point you a murder case. I learned, but you know what? It made me a better lawyer because I figured it out. I didn't have to just rely on it. I went and I did it, and it made me a better lawyer.
Thanks, Judge Baker. Judge Chambers, a judicial role model or someone that you admire from afar?
Yeah, actually, it would be very easy to pick Judge Mills, certainly. It'd be very easy to pick Judge Pope, Marion Pope, who served and retired from Georgia Court of Appeals, served as Superior Court judge here until his appointment. But I think I would select Judge Sam P. Burks. Judge Burks, I knew when I was a child, certainly knew when I started practicing law. Judge Burks never went to law school. He read the law. He had access to law books. And he was admitted to practice and took the bar, passed, admitted to practice, I think it was 1947. And he practiced private practice and then became a Superior Court judge. Then took senior status as a Superior Court judge. And Judge Burks swore me in 1983. And afterwards he looked at me and he said, now Vince, he said, I want you to know, Superior Court judges have more power than all the czars of Russia. I didn't know quite what that meant. But since that time and all the judges I've been in front of, I've been reminded of how much power they had, and it wasn't necessarily in a good way. But I would admire Judge Burks, who earned it. He earned a lot of respect from me and a lot of lawyers in town.
Thank you. And you just mentioned the power of the Superior Court judge, and I would not disagree with you. And so that is a good lead into my next question. My next question has to do with the number of trials or hearings that take place that involve someone other than the Superior Court judges that the people of Cherokee County have elected. And what I'm talking about are visiting judges that may be trying cases. Is that do we do that too much? Should we, is it a matter of us not having enough judges on our Superior Court? Or is it perfectly fine that maybe a third of our cases are tried by judges not elected by the people of Cherokee County?
Is it my turn?
Your turn.
I meant to say this and mentioned it early on and got involved in some of the other stuff. But last week, one of our own Superior Court judges, David Cannon, was injured in a pretty bad automobile accident along with his son. And I don't expect, I haven't heard exactly, but I don't expect he'll be coming up, back to work for some time. Just tonight, I have an attorney on the other side of one of my cases that was here earlier. We discussed this. We have a case coming, or a matter coming up in Judge Cannon's court. He has been hearing this case now for quite some time. It involves a divorce, but it also involves the ownership of a piece of property. And we tend to believe that it would be best for us to wait so that he can hear the rest of the case. But certainly in those instances, you have to rely on visiting judges, we would expect that they are going to apply the law the same way, they're going to apply the respect the same way. And if it's the case that they can hear from beginning to end, I think that's certainly appropriate.
Okay, same question for you. Do we need to be careful how often we use visiting judges? Because while they may apply the law the same way, they're not accountable to the people of Cherokee County.
Well, number one, visiting judges come in a lot of times because of the calendar is so big, and we have our own calendar, so we can't help. I know that they use us a lot, but this is something to let you know. Last year, Superior Court heard 1,165 revocations, 1,195 criminal cases, and 2,719 civil cases. Now, have you ever heard of a civil case being civil? No. People expect, that's nothing, but each judge, so that's 5,079 cases in 2017. Each judge's caseload is about 1,700 per judge. And imagine on the civil case, sometimes those take forever, and criminal cases take forever, and you have to prioritize. So that's where you bring in visiting judges, or you use juvenile court judges or state court judges to help out. So it is appropriate because of the calendaring and of the caseload. It is impossible for 3 Superior Court judges to hear all the cases. If that's the case, the families would never sue. They live at the courthouse, and they do a lot of times. We all do. Secondly, it is appropriate because this still being a small community, although we're growing, we have conflicts. You get somebody on the calendar that went to church with the judge, played golf with the judge, their best friends were in Boy Scouts together. I'm not going to touch it if it's somebody that I know, because you know what? The rules of judicial ethics tell me that I need to get out if there's an appearance of impropriety. And a lot of times the judges all have to accuse to bring in a senior judge so that they don't get the taint. And it's normal. It happens all across the state of Georgia and all across the United States. A judge that sits on a case and doesn't bring in another judge, even though he knows he should get out, that's a judge that you don't want. Thank you.
You're in the hot seat, so I got to ask another follow-up question on this. And I asked it of Judge Cannon and his opponent 2 years ago, roughly.
Okay.
Along the lines of what you just said about needing to recuse, Georgia law currently allows me as an attorney to give, I guess, up $2,600 to a judge that I know I'm going to appear before on a regular basis. Do you have contributors, and I'm going to ask both of you the same question, does that concern you that lawyers that appear before you potentially are able to contribute so much money to your campaign?
For me, check the transparency disclosures with the Georgia Transparency and Finance Commission. You'll see who's contributed to my campaign. It's a small community. If you have a problem with someone donating, more than likely you donated. But that doesn't affect my impartiality as a judge. It's a small community. A lot of lawyers contribute to a lot of judges' campaigns and a lot of other things. That doesn't mean that I favor one over the other. Just because they contributed doesn't necessarily mean they're going to vote for me. Think about that. I'd rather have their vote. But so, to answer your question, if somebody had a concern, they'll bring it up. Prime example before I quit. When I went on the bench, I owned some real estate. I invested in some real estate with a couple of attorneys. And I called, and I got an opinion from the Judicial Council. And they said, you need to divest of those holdings with a lawyer. And I did. I divested, and then the lawyer came in about a year or 2 years later, like, we need to recuse him. He owns the building with so-and-so. They're like, no, you're about 3 years too late. You know, I'm not going to do anything that's underneath. All of mine is going to be above board because my reputation is too much at stake to do something like that.
Absolutely. Well, you don't make these rules. These are the rules we live under. And the same question to you. Do you have any concerns about the legal community donating to your campaign and then representing parties in front of you?
No, I don't. I don't have any concerns at all, simply because my donations have come from family, friends, from clients, people that I would have to excuse myself from anyway. So there's no conflicts there, and I agree certainly with Tony that you can't, you've got to have absolute, be above reproach at all times. I've got 60 years of that, I believe, living in this community. And there are people in this room that will probably tell you more than I really realize about myself, because they've seen me grow up here, and they've seen me in church, and they've seen me in civic organizations, and they know what kind of person I've become, and I'm thankful to to my family quarters.
Reading questions we've received here, and I'll start with this one with you. How many jury trials, civil or criminal, have you conducted as lead counsel in your career?
Gosh. Been 35 years. I don't know how to put a number on it. I can tell you that I've been associated in a number of them, gosh, probably 40 big civil cases as lead attorney, 5 in that time period.
And I'll let you supplement your answer as a judge, I guess, at a municipal level. How many cases have you tried?
We have 300 cases on arraignment day, 75 cases on trial day. I would say over 18 years, probably, and we usually try to get those worked out, and they usually do work out, but I would say over 18 years. And I'm not a mathematician, but hundreds.
Would these be the civil, would these be all misdemeanor municipal offenses?
Yes, yes.
Traffic,
Traffic cases, shoplifting, marijuana possession, alcohol possession, all of those misdemeanor cases.
Same question for you, Judge Baker. How many jury trials, civil or criminal, have you conducted as lead counsel in your career and also as a judge? And I guess civil or criminal, in your instance, it would be a juvenile, but I would like to,
Sure.
I think the people want to know.
Sure. When I was in trial practice as a lawyer, I tried, like I said, between 30 and 40. I'll be honest with you, I quit counting after 30 jury trials. I was lead counsel. That meant it's me and my client, pick the jury trial. If you count associated in jury trials, then you're looking at probably another 50 or 60. So, my jury trial experience as a trial lawyer is pretty vast. And if you associate me in other cases with other lawyers, then it's more. Now, as a judge, juvenile court, they don't have a right to have a jury trial. But in Superior Court, I have assisted with jury trials, but I haven't tried a jury trial because I'm a juvenile court judge. We have just bench trials, and then I have domestic trials in Superior Court, and I have divorce trials, paternity trials. So if you count that, I think you asked that, Mr. Wallace. So in my 11 years, you're talking about thousands of trials that I've conducted. Because like I said, on a civil non-jury day, a minimum of 10 cases, you're looking at least 2 or 3 trials. I've gone as late as midnight and trying cases because for some reason divorces aren't civil. So, counting juvenile court, I'd say thousands, but if you count just Superior Court trying trials, it'd be in the hundreds as judge.
So I'm going to start with you, Judge Baker. Another audience question. What are your thoughts on minimum mandatory sentencing and how it impacts your role as a trial judge?
I think that seeing it as a lawyer and also as a judge these last 11 and a half, 12 years, I've seen where the intent is good, but it ties the judge's hands. Because there are some cases, and I'll give you an example. And again, don't think that I'm soft on crime, and I'll give you this example. A 17-year-old is charged with child molestation with a 15-year-old because she's under 16. And he gets charged the same way as a 40-year-old man who has sex with a 15-year-old. Those are 2 different sets of facts. You got Romeo and Juliet versus an old pervert. But sometimes we don't have the discretion because the law requires that we sentence in the same way if they're convicted. And that is a shame because to me that's totally 2 different set of facts. But the law is what it is, and I will follow the law. I have followed the law. I have said before, hey, my hands are tied. I'm sorry, I can't deviate. And parents, defendants, lawyers, they don't understand. But in the end, I will follow the law, whatever it says. I think it's good, but I think judges do need leeway to sentence outside of that. And they're starting to soften that up because, criminal justice reform has changed it. Because for meth possession, you used to get for second possession of 30 years. Now, it's only 3 years. So they're seeing that it doesn't always work to do that. So I'm in favor of minimum sentencing, but I'm in favor of giving judges more latitude because we are in the trenches. We see it. We know the facts. And the DAs, the prosecutors, they see it. And they need some wiggle room too, because a lot of times they say, we can't do much. This is what it says, and we're not budgeting. So Thank you.
And I'm going to ask you a follow-up question and then ask you both those questions. So if we don't have it, am I correctly interpreting your response as it's a good thing, but it can be used in a way that it renders unfair results? But if we don't have it, is it fair to say that a defendant may receive a much different sentence in one judge's courtroom than in another's if the judges have too much discretion? And is that a very unfair result as well?
Yes, it is. And talking about unfair results, you remember when Zell Miller back in 92, 93, maybe earlier, did the 3 strikes you're out law. 3 strikes and you're done. I knew a lot of people as a lawyer. I had clients. They had 2 strikes on them because they possessed meth, and then they had just a little bit of drugs on them. It was mandatory life. Now, is that fair? Looking back, because the problem back then was everybody says, look, we want to get tough. We're going to lock them all up. Well, but we don't want to raise taxes. And again, I'm not condoning anything, but we don't want to build new jails. How are you going to lock everybody up if you don't have capacity for them? So at some point, it hit the wall. And so they changed, they thought about it, they changed. That's why we've got criminal justice reform, because with addicts, you don't do anything to help them by locking them up on the late teens. As far as doing away with minimum sentencing, no, I'm not in favor of that, because I don't think lawyers would judge shop, and I don't believe that prosecutors ethically would do that either. But you can't control what one judge does versus another, even with minimum sentencing laws. Some judge may give a minimum, and another may give the maximum. So there's a wide latitude, but to say that you can judge shop, I don't think that would happen.
I thought that was a very good answer. I'm not really here to comment on your answer, but I would have to say that I think lawyers would probably judge shop. The lawyers I know. Unfortunately, I don't hold your confidence level in the judge and the lawyer, defense lawyer seeking to find the judge.
Well, they're assigned to different judges, so you can't jump from Judge A to Judge B. You're assigned to that judge, and that's who you get.
I understand. And so the same question for you, and that is, let me reread it. What are your thoughts on minimum mandatory sentencing and how it affects your ability to serve as a Superior Court judge?
I think there are good things and bad things about it. It carries with it. It's certainly good for a defendant out there to know what's going to happen to them, at least what's going to happen to them if they commit that crime. I agree, though, that while I believe in absolute accountability, I believe that accountability has to be tempered by circumstances of a particular case. Not every case is the same, hardly any are the same. I believe also, and I've seen some judge shopping, I've seen some people try to get a case, not necessarily in a civil case, but maybe for the plea because the other judge was tied up, when they know that they're going to get a little bit more favorable treatment. But I agree that there needs to be more discretion for the judge to take into consideration, the circumstances of that case that's in front. Absolutely.
And so my follow-up question to Judge Baker was, it's just a really, really hard issue, and if you give too much discretion, wouldn't you agree then you would have a potential, I guess you sort of answered it, for 2 courtrooms rendering very different outcomes on the same facts?
Yeah, try to answer at the same time.
You did.
And we have seen, we've seen nationally where you go hear about some judge that gave some, slap on the wrist in what we consider to be a very egregious case. We've been pretty fortunate, I think, in this county that the judges are pretty similar in their positions and are just in their positions. And the same thing, I believe, should go, and I agree, that not every case, like I said, is going to be the same. You need to put some common sense into it. And judges ought to have the ability to use common sense.
Well, if the audience will allow, I know it's 9:14. I have one question I have not asked that I want to ask for whoever wrote it, and then we'll go. I'm going to let you each ask a question of your opponent. That's something I didn't do in the prior. I'm going to do it here, so you can start thinking about that, and then you'll do closing statements, and then we'll call it a night. I believe this question is asking for you to pinpoint a weakness and maybe talk about it a little bit. So I'm going to start with Judge Baker. What is your weakest point for this position, I guess, the Superior Court bench. For example, is it education, experience, professionalism? What do you think is your weakest area, in the area that you feel like you should, that you'll have to kind of grow into?
I think with the way that the calendars are, in Superior Court, you're going to be doing a lot of equity, and there'll be some property cases that come along. I haven't done property cases in 11 years since I've been on the bench, so, but the property cases make up about 3% of Superior Court. So I probably have to brush up on property law with all that's going on. That would not be my weak point. I feel like I'm pretty strong in all other areas, because like I said, I've had a well-rounded career, and I've heard a lot of cases on the bench, but I haven't had any property cases. Well, I had like 2 or 3, and that's it. So that would be my weak point. I need to brush up on.
Okay, same question for you.
If you look at my hands, you're going to see a lot of scars. Some have healed and some are still healing, and that comes from hard work and everything I do. That's the way I was raised. I started working in the 8th grade, and I think probably one of my weakest things is going to be understanding that we need to stop on a particular day instead of finish up that case, and keeping control over making sure that everybody else in the courtroom is accommodated as well.
Okay, so I'll start with you and allow you to ask a question of Judge Baker.
Now, I don't know how was that? You can drip, you went on now.
You can decline, or you can just ask him something about, you don't have to send you can send a softball or whatever you want.
Only, that's a question.
This is usually where you go right at wherever you think your strongest point is.
Not really. I don't guess. Tony, in the last 10 years, you've been juvenile court judge. Have you had during that time period any exposure to any other law?
Yes.
And what was that?
Well, I've done all kinds of civil, except like I said, I've had about 3 property cases. I've done torts. I haven't done any wrongful death, because we don't get a lot of those in Superior Court. We get them in state court.
I have.
I've done fraternities. I've done family violence, more than you can care for, trying them all. I've done divorces, complex divorces. I've done complex criminal cases. I've tried them. So the only thing I haven't had exposure to, like I said, was property. And I had 2 or 3, and that's it. So, but overall, the judges have trusted me with their calendar and their cases to run with it. And so I have. In fact, there are a lot of times where lawyers will have a case in juvenile court that runs concurrently with the Superior Court, because the parents got a drug charge, and the Superior Court they got a drug charge. The lawyers will come and say, Judge Harris, Judge McAleer, Judge Cannon, we want Judge Baker to hear this because he's familiar with the facts of the case, and we know that he's going to be fair. So I will do whatever I can to accommodate the lawyers, and I hope I'll continue to do that.
And so now it's your turn to ask a question of...
Burn one in.
No, he can't after that.
So, how many, I noticed when Mr. Wallace asked you about your jury trial experience, how many have you been lead counsel from beginning to end?
Yeah, I think only about 5.
Okay. All right.
Most cases, in fact, you'll notice now, most have multiple attorneys involved. Because it takes quite a while to get a civil case to trial. And you don't have many civil cases. Mediation, which is something we haven't discussed, is one of the great things I think that's come along to help resolve cases.
I actually had that in my head. I never asked that question.
Push mediation.
Do we push mediation in Cherokee County
It's
now?
required.
It's required?
Mandatory in civil cases, especially domestic cases. You don't go to the final until you go to mediation. It's required.
All right.
And the definition of a good mediation is nobody lose happy.
Right. I mean, is it successful? Are you resolving a good percentage of cases in mediation in Cherokee County?
It was all half of them. But
That's a pretty
when
good
I say mediation, I'm talking about it was all half the issues. The other half has come before you.
And so folks, I know I'm taking up a little bit of your time, but that's important, and that is to get the case to move along, forcing the parties to sit down with a mediator and try to resolve their case before it spends 2 years in the court just pocketing up the docket. Get rid of the ones that are resolvable, because if you convince the parties that it's going to be a whole lot better if they resolve it themselves, then that's a good thing. So now we'll go into closing statements, and I believe I allowed you to go first on the opening, so I'm going to let you go first.
Okay, thank you very much. Like I said, my name is Benson Chambers, and I've been practicing law here for 35 years. Grew up in Cherokee County for 60 years, 60 years old, and just now turned 60, so I'm having a hard time remembering to say that instead of 59. But I would appreciate your vote for judge. I've had 35 years of experience with exposure to both civil and criminal cases, and I believe that experience will help me help you as a taxpayer, as a participant in court, a hard-working judge who's going to show up on time every time to get your cases moving.
Thank you. Judge Baker.
When you get out of law school, there are two tracks you can take, and that both tracks are equally great. Don't get me wrong. You can be a transactional lawyer, or you can be a trial lawyer. I got out of law school, and I was a trial lawyer. And since 1975, if my memory serves me correct, and the records serve me correct, since 75, maybe even before, every Superior Court judge this county has been in the trenches and was a trial lawyer. There's a reason for that. They are seasoned. They know how to try cases. They know how to control lawyers for the most part. Okay? Now, why do I want to be a Superior Court judge? To me, I love being around people. Those who know me know that I'm 110 miles an hour all the time. I love being in court. I'm passionate about what I do. I've got the energy. I've got the diligence. And I've got the faith in the system and the lawyers. I am an optimist, and I believe that people deserve their day in court. But at the same time, I will tamper it down if they take the use of the system. I've been a part-time Superior Court judge sitting by designation for 11 years. It's a natural progression. You know, looking back, my career, I didn't know it was headed this way. But I prayed about it. And when the vacancy opened up, you know, one opened up 6 years ago, and people were like, why don't you run? I just didn't feel like it was my time 6 years ago when Judge Mills retired. But now is my time. And I've never run for a position or done anything just for the sake of doing it. Being a Superior Court judge requires a lot of time, a lot of energy, and it is hard work. I'm ready. Juvenile court, I've heard some bad cases. I've learned. It has steeled me. My resolve is here. I've done the job. Now it's time to do it full time. And to be honest with you, I'm doing it because the community deserves a judge that has the judicial experience. And I've got that. I've tried thousands of cases. And I miss trying cases in front of people. I miss jury trial. To be frank with you, I miss it a lot. You know, you hear a bunch of kids and adults fussing, but I want jurors to decide, because it takes a toll on you when you sit as a judge and you try divorce cases in custody. That takes it out of you. And when you decide about defects kids and what parents should do, that takes it out of you. I'm ready to try jury cases because I want to interact and I want to take my energy and my experience to the Superior Court. And so I'm going to ask for all of you to vote for me on May the 22nd. But I want to remind you, you can early vote starting April 30th. Okay? Early voting April 30th, May the 18th. Then you can go on the 22nd. Come early if you want to vote early and vote for me. Thank you.
Hold up, pause real quick. I just want to thank both of you, myself, for coming and answering the questions. I thought we had a great dialogue. You answered the questions I asked. There wasn't a lot of politicking in the back and forth, and I thank you, and I appreciate both of your time. Thanks, everybody.